Hi, I'm Tim Clarke. I'm a director with Clarke Chartered Surveyors. And in this video, directed at commercial landlords, we'll be considering how you can deal with your tenant's dilapidations at lease end. About a year before your tenant's lease ends, you should ask a specialist dilapidations surveyor for advice. While a year might sound too soon, taking advice at this time can ensure that you will be in a position to fulfil your obligations to protect yourself or your property company from loss. Specifically, taking advice early can safeguard you from losing the right to require reinstatement of your tenant's alterations if your lease stipulates that you must provide notice of this before the lease ends. Sometimes a lease might require you to give 6 months notice or more for removal of alterations. Because of the potential to lose the right to require the property to be reinstated to a former state, if there is any uncertainty as to whether your tenant will renew, we recommend that you serve a schedule of dilapidations to protect your position. In some cases, this may not be necessary, but your dilapidations surveyor will be able to advise on your exact circumstances. Under the Limitation Act 1980, a lease is classed as a specialty, meaning that claims can be brought up to 12 years after the lease has ended. As such, late service is not always especially problematic, although this can depend on the exact wording of the lease. As mentioned, if a lease requires the landlord to provide written notice that they require alterations to be removed, this must be done either within a timescale stipulated by the lease or at least within a reasonable time prior to lease end. The notice must give the tenant a realistic opportunity to reinstate any alterations. If you have left it late, your dilapidations surveyor will advise you on your likely dilapidations recovery. It may be that your surveyor can mobilise quickly to maximise your dilapidations recovery. As with everything dilapidations, the position will depend on the exact wording of your lease. Traditionally, schedules of dilapidations have been formally served on tenants by landlords' solicitors. The dilapidations protocol sets out how the courts expect a dilapidations claim to be handled. The protocol does not require schedules of dilapidations to be formally served and refers only to the sending of the schedule. Many clients still like their solicitors to formally serve the schedule, particularly if this will be completed at their tenant's cost, as is common. This covers all bases, as there may be a particular reason that service is necessary, such as to provide a formal notice to reinstate. It is, however, often unnecessary. Other than the cost, the main downside to formal service by solicitors is that it slows everything down. There is often no reason why the surveyor cannot serve or send the documents, and this is often a suitable choice, particularly if time is tight. In the past, I've been involved in a court case where the schedule was prepared in time to require the property to be reinstated, but due to delayed service by solicitors, the landlord lost their right to reinstatement. This was frustrating for all parties as the dispute hinged on the requirement to reinstate. Assuming the claim has been sent to the tenant prior to lease end, it is the tenant's choice whether they want to complete the necessary work to address breaches of the lease, or whether they would prefer to pay financial compensation, also known as damages. It is typical that a tenant will accept some liability for dilapidations but refute some other dilapidations items, which often leads to a period of negotiation. You should think of a schedule of dilapidations as a technical record of lease breaches, and dilapidations surveyors will use this document to reach an agreed assessment of loss, which is likely to be lower than the initial schedule total. The reasons for this are numerous, but the key is that any dilapidations payment should only be made from the tenant to the landlord to address financial loss, and a dilapidations payment should not be seen by a landlord as a bonus payment for dealing with a void or a change of tenant. We always recommend using specialist dilapidations surveyor to ensure that your dilapidations loss is minimised and recovery of damages maximised. Dilapidations is a specialist area of law, and you will want to ensure that you have the best representation available. For this reason, you should ensure that your surveyor is a true dilapidations specialist, like our team of specialist dilapidations surveyors at Clarke. If one of your commercial tenancies is coming up to an end, or even if your tenancies are mid-term and you want to plan for the future, our team of surveyors are on hand to provide the advice you need. We can be reached on 023 81 55 0051 and look forward to hearing from you soon.